What I'm about to present here today is very, very important. I've been an attorney for a bunch of years, and over the years at Cetera, which is pretty close to 29 years at Cetera, I've had a lot of opportunity to talk to both advisors and their clients like yourself. And there's a lot of misunderstanding about estate planning and the different elements and pieces to that. I hope to demystify that for you today. And certainly, if you have questions at the end, we'll be more than happy to answer them. Will, next slide. Next slide. Okay. There are really, in my opinion, 4 different buckets when we talk about estate planning. The first I'll talk about is power of attorney. What is a power of attorney? A power of attorney is a document that one signs to give another person authority to act for them. It can be either a general power of attorney, which is a document that gives the person the ability to do everything for you, or more specifically, it could be a special power of attorney. Many of you are located in the San Diego area, and many of you are connected with military individuals. If a person in the military was going overseas and wanted someone to sell their car, they might give them a special power of attorney, which means for the limited purpose of selling the car only. So a power of attorney is a very powerful document, and it really can have a duration of with no expiration or a specific time frame when it expires. So it allows a person to act for them in that capacity. The next item I'd like to talk about is the healthcare directive. This is a document where you can actually make known what your desires are for end-of-life issues. In other words, using a terrible example, if somebody's in a coma, does the person have the authority to continue them on life support or not, and things of that nature. And there are many variants, and that obviously should be discussed with the doctor as well as your attorney. The next item, which is a very common item of discussion, is a will. What is a will? A will is a document that is executed in California and in other places as well. It requires a certain number of witnesses, California being 2 in number, and it must be written in form and signed properly. The document basically describes what you want to happen in the event of your demise. You can have any number of contingencies in it, but it can be very, very specific, or it could give everything all to one person or to several people. That just depends upon what you want to do. I might add that in looking at a will, you need to look at that in conjunction with your overall financial plan with your advisor there at the credit union, because that is an integral part of understanding what you want to do with a will. A trust is a totally different document. A trust causes the items named in the trust to become trust assets. And what does it mean? If I have a house and I put my house in trust, the trustee has the ability to sell that house or to do whatever you want. And in that capacity, the trustee has tremendous authority. The difference between a trust and a will is a will, by definition, requires a probate proceeding. A probate proceeding is a proceeding in court which changes the name on a certain asset. The court has the power to do that. A trust goes beyond death, meaning that the document does not require a probate and merely changes the title or the name as to who gets the asset because the trust says so and the trustees say so. Next slide. There are basically, when we talk about trusts, a couple of things you need to consider. When I create a trust today, the trust is revocable, meaning that I can revoke it at any time up to the moment of my death. And I could change that document every day of the week, and I could change the provisions, etc. of it. And when I'm reporting things that are in the trust itself that way, when the trust is revocable, all the tax ID is under my own Social Security number. So any earnings of the trust gets reported under my Social Security number, and therefore is reported under my own tax return as such. As I say, one of the reasons that you want a trust is the following. If you live in California and you have property in other states, as an example, you may have a condominium in Colorado. While you have a probate proceeding here in California, California court can only change the title to real property in the state of California, and all other assets that you have anywhere where they are, they can change that. But if it's real property owned, say in Colorado, and you live in California, then it's an issue because a trust has to basically be created such that you list the out-of-state property as to where it goes, because otherwise you would need a separate probate proceeding in the court in Colorado. But a trust could take care of that, because when I die, the trust that was revocable now becomes irrevocable, and therefore the terms of the trust can be carried forward. So no probate proceeding is required in California nor in Colorado. The trustee that's named after my death continues on. In other words, it's part of the trust, and the trustee makes those decisions going forward. So the house or condominium that you own in Colorado can be sold immediately after death by the trustee, whereas in a probate proceeding, you have to await the probate court determination in Colorado, a separate probate proceeding. That could be expensive and very, very costly. I might give you this example. If there were two condominiums in Colorado, one of which had it by probate proceeding and the other by trust, the probate proceeding could take months. Therefore, the property could not be sold immediately. And two properties, A and B, one owned by the trust and one in a probate proceeding, the difference is that somebody would pay more money immediately to get the property, as long as it's from the trust, because that can be done the next day, where the probate proceeding would take months. So it's very important, if you own property out of the state, to consider having a trust. As I say, an irrevocable trust becomes a separate identity, a separate tax identity that's created at death. It could be created during lifetime as well. And what it amounts to is the trust is taxed at trust rates. Let me just give you an interesting example. When I was in law school, I did research work for the dean of law school, and the dean had 11 daughters. And I used to meet once a month for dinner at his home. And I was marveled, because I come from a family of 2 siblings. And I was marveled at the fact that you could have 11 people eating dinner at one time. And his wife was pregnant for the 12th time and finally had a boy. The reason I'm mentioning that is, it's my observation over the years that if you have 2 or more children, generally speaking, one of those children is a bad child. Bad in the sense they may be involved in drugs, alcohol, gambling, or whatever. And you as the parent might consider what I call an incentive trust. An incentive trust is not a legal definition, but really is one that I create. And what do I mean? You could, on your death, create the trust, and the trust in a language that would say that, quote, that bad child, in fact, could get money from the trust if they're sober for so long, if they involved in Gambling Anonymous or whatever else it is, or if they squander money, if they save so many dollars, they get money from the trust. You could set the parameters as to how and when that, quote, bad child gets money from the trust. And that's something that could be considered. And this is something that you should actually discuss with your financial advisor at the credit union to help you in that regard. Next slide. You know, it's an interesting situation. When I first started with Cetera in 1997, the total amount of dollars that could be exempt from federal estate taxation was a mere $600,000. And most people who live in California know that their residences alone amounted to more than $600,000. So typically what you have is you have to look to see what the total amount of dollars that can be exempted from any federal estate tax. As it turns out, in 2025, the magical number now has grown to $13,999,000. And in 2026, it will come out to be $15 million. That is a very significant number. And most people do not have assets that large. If one dies, the amount of dollars below that, that is not part of the estate of the one that dies, is then in the pocket of the surviving spouse, meaning that the surviving spouse has that extra money that they could die with, that money that was never part of the amount that was taxed from death of the first spouse. But I must caution you that other states have much lower thresholds. In California, there is no state estate tax, but other states have much lower numbers, maybe as low as 600,000, 700,000, etc. That's very important to understand. Next slide. What I really should talk about is, before I get to this, I should talk about the concept of the surviving spouse. When you have a surviving spouse, no matter how many assets I have when I die, all the money can go to my surviving spouse when I'm dead. And there is no estate taxation between spouses. The name of the game really is to then carve out, if you would, the most amount of money that could escape estate taxation. And what you do is you look to see how much dollars is really at issue. Let me explain a couple of things. Many of you have 401ks and qualified plans, and you have IRAs, and you have the IRAs probably at the credit union. I might add that there's a big difference between a 401k and an IRA. Why do I say that? A 401k is subject to federal protection under ERISA. And under ERISA, there are many, many attributes of ERISA that protect the 401k. Let me give you an example. When O.J. Simpson had his difficulties and he was getting $250,000 a year from his NFL qualified pension plan, the persons that had claims against him, in fact, I think it was his own children for that matter, they had a judgment. They could not go to the custodian of the qualified plan and demand the money. Only after the monies are paid out annually to him could they attach that money. In an IRA is a creature of state law. And as of April of 2025, in bankruptcy, an IRA was protected for $1,711,975. I might add that aside from bankruptcy, if somebody has a claim against you and you have an IRA, the question is whether that judgment that they get can in fact be held against you by the custodian who has your IRA. And that's the difference. There's a difference between an IRA in bankruptcy, being protected for that 1 million plus number, and in a judgment creditor situation. Oddly enough, states across the United States have different rules. Some states say that an IRA is fully protected from a judgment creditor. Some states say not. Oddly enough, California is unique. California's rule is that an IRA for a judgment creditor is protected only for as much money as the judge thinks is reasonably necessary for retirement. So that's very much unknown until the court makes their decision. And as I say, there's a big difference between IRAs and qualified plans. And again, an IRA is state law driven as such. Next slide. I alluded to a fact a minute ago and the following. When a spouse dies, the surviving spouse can inherit all the property of the decedent spouse, and there's no federal estate tax no matter how much they have, because between spouses, there's an unlimited marital deduction. However, there is in the code a provision for allowing an exemption up to a certain amount of money. As I say, currently, that number is over the 13 million plus number. And so most attorneys, like as I gave you an example, back in 1997, when the magical number was 600,000, most attorneys created what's called a bypass or a B trust. Why do you do that? Because the name of the game really was to take as much money as the federal law allows to go to a non-spouse and have the money in the asset portfolio of the non-spouse, say the children, so that money would grow in their estate and not in the surviving spouse's estate. So that's very, very important. The problem is that because that number has grown from 600,000 to next year going to 15 million, most individuals have less than the $15 million of assets. And therefore, most attorneys, when they created these estate planning documents, usually listed the bypass trust to be funded first. And therefore, if you fund a bypass trust first and you have $2 million of assets, then all 2 million go into the bypass trust. What does that mean? In a bypass trust, the surviving spouse gets annually income from that trust, but is not entitled to get principal, only a certain very limited amount of principal. So therefore, all of you that have estate planning documents, you should be looking to review them with your own attorney and your financial planner to see whether the bypass trust is created, and if so, if it's created first, because you might want to change that before the first death occurs. Because once that first death occurs, there is a locking in, the trust becomes irrevocable. Again, as I said earlier, the trust being irrevocable during the lifetime of both individuals can be changed. Now, I might add, on death, there automatically is a stepped up basis, meaning that if I have an asset which I paid $20,000, say I have a mutual fund, and today it's worth $100,000. If I cashed in the mutual fund today, I'd have $80,000 of gain, and I pay capital gains tax on the $80,000. However, on my death, I get a stepped up basis, meaning that the $20,000 goes to a cost basis of $100,000, so that whoever inherits that mutual fund starts out with a cost basis only cost basis of $100,000. So they sold it the next day, there'd be no taxes to be paid. So it's important to recognize that the decedent's portion on death gets stepped up. In a community property state such as California, there is a quirk. I say a quirk. It's a law that goes back to 1947 that was never changed. In that case, both halves get stepped up. Both the half of the decedent gets stepped up, as well as the surviving spouse. So all the assets on death of the first spouse get stepped up to the basis, the fair market value on the date of the first spouse dying. That's very, very important living in a community property state. Next slide. There are various techniques that can be used. I talked about a mutual fund. If you have a mutual fund and there's a gain in it, and you sell it right now, you're going to pay tax on that. Instead, you could donate that mutual fund to what's called a charitable remainder trust. That is an irrevocable trust. What happens is you give the assets to the charitable remainder trust, and the charitable remainder trust sells the asset. They get to sell the asset, in my example, at a fair market value of $100,000. You who did that get annuity for your lifetime at the fair market value, meaning that you now have an annuity going forward of $100,000 in value. And at that moment in time, you do not pay any tax. You will nonetheless pay tax as you receive annuity payments over your lifetime for each payment. And in addition to all that, you also get a charitable deduction measured by the expected end value of that CRT on your normal expected date of death. However, when you do this, you are basically giving the asset to the CRT, they sell it. You can no longer on your death designate where it goes. All you can do is it must go to a 501 bona fide charity on your death. And there are variants of the CRTs. One is called a CRAT, which basically it gives you a fixed amount annually. The other is called a CRUT, which gives you a fixed percentage of the value. And then there's an IMCRUT, which says you can hold the value of the amounts earned in reserve and tap the money later on. But a CRT can be a very effective mechanism. And I submit to you that if any of you have assets that have a low basis that you're looking to sell, please talk to your financial advisor at the credit union, and they can be more specific as to how they can help you in that regard. Next slide. As I say, in the past, there's a concept called an irrevocable life insurance. Generally speaking, if I create a life insurance policy and I name a beneficiary, that beneficiary receives the assets or receives the payment on my death, income tax free. And if you set it up as an insurance trust, it's out of my estate, so it's estate tax free as well. And that can be a very, very powerful tool. Certainly, the use of insurance is very important. And here, once again, that's an item that you should be discussing with your financial advisor at the credit union. Next slide. Let me give you some best practices that you should take away. You know, sadly so, COVID taught us many lessons. One of the things that I see is that it really enhanced the interest in getting long-term care. In California, as well as in other places in the country, everybody wants long-term care. The problem is it's darn expensive. There is a unique feature of the Internal Revenue Code that allows you to take money from a non-qualified annuity, meaning the annuity that's not in a qualified plan, and you typically create that qualified annuity to get money at a certain time in retirement. And if you take the money out before you annuitize that contract, in other words, start getting money, and you just take a distribution, you pay significantly taxes because you have to pay a percentage of the gains on that. Now, in a 1035 exchange, you can effectively take portions of a non-qualified annuity from that annuity carrier directly to pay the premium of a long-term care carrier. You cannot get the money into your checking account, but it can go from one insurance carrier to the other carrier. And that's a very good way of paying the premium, such that the money from the non-qualified annuity moves over to pay the premium without any tax consequence whatsoever. Now, obviously, if you have a long-term care policy that works well, you could do this with a new policy you want to get. But of course, in order to get a new policy, you have to be health insurable. But that's a feature, once again, you might discuss quite clearly with your financial advisor at the credit union, because they can help you and discuss with you the merits of doing that. Let me give you another very powerful tool that is now available. If you have or create today a corporation, a C corporation, and you have stock in the corporation, if you hold that stock for 5 years, 4 years, or 3 years, let's look at the 5-year situation, and you hold that stock for 5 years and you sell the stock at the end of 5 years, you pay no tax on the gain, no capital gain tax, and no alternative minimum tax. All the gain is tax-free. That is incredibly powerful. If you parlay that with a small business administration loan, then it's even more powerful because you're not even using your own money. Obviously, if the business is not successful and the value of the stock is worth less, it doesn't matter. But if it's worth more, you get all the value, as I say, tax-free. And the law was just changed such that before this, you had to hold it for 5 years and you got 100% forgiven. Now you can hold it for 4 years and get 75% given, or 5 years, or sorry, for 3 years and get 50% given. That's a very, very good feature. And for many of you that have children that are just graduated college and don't know what they want to do, they can have an entrepreneurial idea, and it's a great way to seed the money for that. And if they're successful, what a powerful tool that is in that regard. Next slide. Let me open this up now for questions that you may have. Again, my purpose in doing this is to basically explain to you some of the basics of estate planning itself and the role that financial planning and your financial advisor and the credit union plays. Because all these things are aspects that you should be discussing with a financial advisor as the strategies and the uniqueness of what you otherwise have. So I'll open it up to questions. Will, I'll turn it back to you.
Yeah, Stan, thank you so much for that valuable information. Just want to remind everybody that if you have a question, you can either put it in the chat or in the Q&A. We'd be happy to answer any questions for you. Stan, are you ready for some questions here?
Sure.
I got a question here that came in through the Q&A. How do I start the trust on my property in California? I have 2 children, 23 and 19 years old. I'm eager to put this trust legal docs sooner than later. I believe the California house is a conjugal property. Even the title is named only to the husband. Ken, any comment about that?
Yeah, it's interesting. Just in California itself, California being a community property state, in essence, you can have separate property. And the way you're describing it, it sounds like the house itself is really right now the separate property of the husband, which means you don't have any ownership rights to that. So in reality, the husband, because he has the property, he can in fact create a trust in his own right, and he can cause that trust to then, on his demise, distribute that asset wherever. He could distribute it back to you as the surviving spouse, or could distribute it to the children. But again, regrettably or not, you as the spouse right now, you don't have ownership rights to that, so it can't be part of your trust. He, in fact, could change that title today while you're both alive and make it such that both of you own the property. There are a lot of consequences or practical considerations. He may or may not want to do that for other reasons. But yes, he can have the trust for himself, but you have no rights to basically, at this moment in time, do anything with that house until and unless he changes that in that regard.
Thank you, Stan.
By the way, I should have added one thing that's important.
Oh.
In California, all assets that are owned as separate property can be changed to community property merely verbally. In other words, if it was other than a real property, if it was like a bank account, he effectively could say, I'm giving my spouse half of that money, and his oral statement is recognized. In real property, it must be in writing. So in your particular case, you'd have to physically change the actual ownership, the deed, etc., to get that done. I'm sorry, go ahead, Will.
Okay, excellent. Another question is, if I'm married in California and we both own one property jointly on the deed, do we need a trust? My 401k has my husband as a beneficiary. Do we need a trust?
Interesting you say that. I could have covered that too. Aside from all the concept that I talked about, a will and a probate and a trust, technically speaking, if every asset that you have has in it a beneficiary as such, or in fact has a transfer on death at the end of the titling, then you wouldn't need a will, you wouldn't need a trust, because a beneficiary driven item like an IRA on your death automatically follows the beneficiary of rule and is not subject to any probate proceeding, and frankly, is not part of your will, because that beneficiary designation trumps the will. And so, to your point, if you in fact have the beneficiary-driven item, that's not part of a trust. The question is, do you need a trust or not? My comment to you is, I think you should consider a trust when you have property out of the state, certainly. When the property is not out of the state, it's not necessarily required as such. You could effectively transfer most assets, as I say, by beneficiary, or you could create a bank account that transfers the assets on death. You could also, if you're a surviving spouse and you have an account, tomorrow you could go to the bank or credit union and you could change that account to joint ownership with you and your son. And therefore, on your death, that co-owner automatically owns the balance of that account. You may not want to do that because that gives him the immediate right to take money out of that account, much like you. You might instead want to have a transfer on death, which only becomes effective on your death. So prior to your death, he cannot take the money out, nor can any judgment credited against him take that money prior to your death. And that's the real difference between that. But again, these are all considerations that you need to discuss with your financial advisor. And each one of you on this call has a different factual scenario that you really should sit down and plan with your advisor. Because I hate to say it, you never know when death occurs at any age for any reason whatsoever. But these are discussions that should be had.
Excellent. Kind of a follow-up to that, asking for clarification. Did you say that most homeowners need both a will and a trust?
And again, I guess the concept is, technically, if you have a will, you wouldn't need a trust. Because whatever you could do in a trust says who gets the money at certain points. And the only difference is the trustee of the trust after your death has certain parameters as to when they pay out the money. In a will, effectively, it's a one-shot deal, meaning that when you die, you'll give it to your son. You could have stipulations on that, but that's rare. So when you're concerned about the immediacy of payment to your heirs or to whoever you have, then you should be looking towards a trust for the uniqueness of what you could do in the trust. But again, I caution you that when you have out-of-state property, that's really something that you really do want to have a trust, because it's darn expensive to have a mini probate proceeding in a different state, to hire an attorney, to go through the court proceeding, give notice. It just eating up your money. So, but again, this is something you should discuss first with your financial advisor, and then, as appropriate, with your own counsel of your choosing.
Yeah, the follow-up to that also was related. A follow-up question was, in order to avoid probate with property in California, can you just have a trust and no will?
Yes.
Yes. Yeah.
Yes. In other words,
So.
you could create, yeah, absolutely, because that's the point. The concept is that a trust survives your death and acts as a separate ruling document as to what happens thereafter. The court does not become involved in that. That's correct.
Excellent. Another question about, you mentioned something about taxes and stock. You said free taxes in a stock after owning the stock 5 or more years.
Yes. What I'm saying is, it sounds weird, but it's fact. If you create a company today, or if you create a company today, and you have stock that I own 100% of the stock, or whatever else I own. If I hold that stock for 5 years and 1 day, and I sell that stock, ordinarily, you would pay tax on the gain on that stock. That's the nature of the tax code. However, there's a special provision that allows you, on this code section 1202E, that allows you to sell that stock after 5 years, and no matter what the value of that stock is, if the stock was worth, say, $50,000 when you started, and is now worth $400,000, the $400,000 on the sale of the stock 5 years down the road, you pay no tax whatsoever on that. You pay no regular income tax, you pay no capital gain, nor do you pay what's called alternative minimum tax. It's all tax-free to you. That is huge. And the only difference is, under the recent tax legislation that just passed in July, they've now modified that. Instead of a 5-year period, they've made a provision for both a 4 and a 3-year period, where you get less than 100 cents on a dollar being tax-free. You get either 75% or 50%. But again, that's huge, because you avoid the taxation down the road. So that can be very, very powerful, to say the least. Assuming that the business is worth more 3 years, 4 years, or 5 years hence. Yes.
Thank you. A question about thrift savings plans. Are thrift savings plans protected?
That would actually vary in part upon state law. It really depends. Yeah, they're in a very unique position, to say the least.
What about for California?
In California, I believe that is protected, actually. Yes.
Okay. Okay, beneficiary question. Some important ways to leave assets to kids. Financial institutions will use the list of beneficiaries. Residential properties can use a transfer on death, at least in California. With this in mind, when are a will or trust really valuable?
If I had the answer, I would have written a book a while ago and I'd be retired somewhere. A couple of thoughts I want to give you. I mentioned before that when you have 3 or more children, it's my observation that one of the children has a problem. And many people look to see how they can best make that work. And so many people have suggested that the 2 good children get 50% of the money instead of a third. And they, out of their goodness of their heart, at some point will provide for that third sibling. The problem is that it doesn't work that way. Why? Because each of those 2 good children is married to somebody. And their spouse will say, why the heck are we giving your brother or sister any of the money? So my comment to you is there's no silver bullet. It really depends. Again, I go back to the concept that if all you have is beneficiary driven or transfer on death, then you need not really have a will. But having said all that, what if you, and I certainly wouldn't happen in my world, what if you win the lottery overnight? Now you have more money in your account than you ever thought you'd have. And it's not beneficiary driven. So you need a cleanup document. You need either a trust and or a will to cover, the things that you forgot to list. And that's why you might do that. But here, once again, this is a conversation I think you need to have with your financial planner as to the uniqueness of your situation. And this actually varies a lot depending on when that you're married, first marriage, second marriage, or third marriage. And I also say, one of the things that we see quite often, when one remarries and when one gets divorced and remarries, it appears to me that you typically marry somebody of the generation younger than you are, which puts them right in play with the same age as children from your first marriage. And that creates a lot of consternation as to how you leave assets to both children from the first marriage and your surviving spouse. But here, once again, there are numerous strategies that we can discuss or should be discussed, but your financial advisor can really get into the nitty-gritty of that and discuss with you the uniqueness of your situation.
Excellent. Another question came in. My girlfriend has children and I do as well. How do we set up a trust to make sure everyone gets what we wish? We own a house together and property on our own. Do we need 3 trusts?
Okay. You certainly need a trust for the assets that are individually owned by you. If I hear correctly, what you're saying is the house is actually owned jointly by both. If that is the case, you really need to have a trust, and I guess you could create a joint trust for that matter, that would put the house in the trust, and then the trust would show what happens on death. But let me throw this example out to you. In that example, is it your intention then to have children from each of the 2 marriages own the house? If I heard correctly, you each have 3 children. So you end up with 6 owners of the house, and that's not going to work well because they all can't live in the house, and some will want to sell, some won't want to sell. So you really need to be thinking about what the end game plan is. And once again, I think it's more a practical question, and I think your financial advisor really can sit down with you and go through this and explain to you what the variances are for you. But that's a very interesting concept.
Yeah. Not very common nowadays as far as owning assets and having children. Another question that came in. We were married in California and now live in Virginia. Both of our names are on the title of our house and designated as beneficiary for all my accounts, including my thrift savings plan. Do you recommend a trust?
No, not necessarily. Well, again, so you're not living in California. The property is in California, if I understand correctly. I guess in that case, if the property in California is in a trust, no problem at all. If it's not in a trust, much like I said before, you run into the situation where on death, where you're living, you'd have a probate proceeding, but they can only control real property in their state and not the property in California. So yes, In that case, I think you should have a trust to cover the California property to describe what happens on your death. Other than that, you'd have to get a court in California basically to step in a probate proceeding to basically adjudicate as to where or how the property goes. And even if you had a will, it would go by virtue of the will. If you didn't have a will, then California probate code has certain order of hierarchy as to who inherits. But yeah, in that particular case, yes, I think you should have a trust with the property in California being in that trust, and it may be the only property in the trust, but that's okay too.
Yeah, I think the follow-up, they're saying that the property is in Virginia.
I'm sorry, I misunderstood.
The property is in Virginia.
And let me be clear, when you got the property, the question is, were you living in California? I guess the question is, was the property really a community property when it was acquired? That's the nub of the question. But either way, if the property's in Virginia and you're still not living in Virginia, you're living in a different state as well, I think that's the question, then you really would need a trust to, once again, avoid a probate proceeding in Virginia.
Okay. And then as it relates to people living in different states, if you have a home in California, does it matter where the beneficiaries of the house live?
No.
You know, when you list them on the trust, does it matter?
No, that doesn't matter. Not at all. No.
Okay. Then another question in regards to, is there anything specific to be done for placing firearms in a trust?
Not that I'm aware of. It's like any other asset that you own. It's just whether you own a car, you own a firearm, it's just however you designate it, you know, what happens after death. Nothing unique. The only real difference is, I guess, if you designate a firearm to another individual, then local law may step in as to whether they can, in fact, you know, what's required for them to own it. Different states have different registration rules as to whether it has to be registered or not registered. But no, as far as the actual ownership change, that does not matter. It's just a question of whether they comply with the local ordinances.
Okay. Another question, and it might be common for a lot of us. Here's a question: the couple, they're not married, but they have two children, ages 6 and 4. They have a house that's joint tenants with right of survivorship. They have money in a joint account and individual accounts, stocks, retirement accounts. What can we do to protect our money and home to make sure it goes to one another if we die and not our parents or next of kin, since we're not married and the kids are underage?
Yeah. Well,
because you mentioned kids that are underage could not
right.
get it.
There are two things to look at. One, typically when a child inherits an underage child, somebody has to step up, usually in the court system, to become the guardian, or basically the guardian for the child, both for the physical well-being as well as their financial well-being. And each state has different processes by which they appoint individuals as to who's in charge. One person can be in charge of the physical child, and another person be in charge of the assets of that child. So that's one element. As far as the fact that you're not married, yes, it's important that you make sure that all those assets are, once again, beneficiary driven or co-ownership or whatever. But if you fail to have an asset that is listed in a trust like that, then regrettably, if there's no will as such, then the local state law governs. In California, it basically would go automatically to the children. There's a certain hierarchy. And then if there are no children, it would go to the parents. So, and if you're not married, usually it would go to the spouse, but if there's no spouse marriage, then the children could step up. But again, if there were no children, then it would go to the parents. And again, each state varies that hierarchy in terms of what they provide without a will. And they always joke about that the state determines where your money goes to. But as long as you continually have your assets, so it's beneficiary driven or something of that nature, then you need not be concerned. But that's something that you should be considering. And here, once again, because the complexity of all this, I think you should sit down with your financial advisor to go through the parameters and the what ifs, etc., and see what his or her recommendation would be for you.
Excellent. Yeah. Question about guardianship. For a guardianship, do you have to have a will, or can you write a letter and have it notarized?
I guess, but either way, even if you have a will and you name who you want to be a guardian, for some reason, the court feels it has what I'll call plenary authority, meaning that they alone make that decision. They don't necessarily have to follow what's in a will or even in a letter. It is merely a request that you're making of the court, and they will then do what they think is in the best interest of the child. Using a silly example, if you designated your brother to be the guardian and your brother is a drunk or sister is a drunk, then notwithstanding your recommendation for the brother, if somebody says, hey, the person is the guardian is a drunk, then the court's going to say, wait a second, we recognize what they said, but we're going to find what's in the best interest of the child. So either a letter or the will does not have any greater effect. The judge makes that final decision, and by a variant of considerations, they look to what other people say.
Excellent. Can you speak to how to the right vesting for a married couple, you know, joint with rights of survivorship, tenants in common? Is there a best vesting for a married couple?
Joint tenancy is such that on death of the first spouse, the surviving spouse automatically inherits that decedent's half. Okay, so it's joint; it just goes to the secondary person. A tenants in common is different. Tenants in common is more of a partnership, meaning that when one person dies, that interest can go anywhere else. It doesn't have to go to the surviving spouse. So the difference is a tenants in common is really a partnership type of thing. You can give it to somebody else. So that's typically for real property anyway. That's not done that way because it creates a lot of, it creates two different sets of people owning the same item, and they may never agree. And they certainly both can't live in the house if that's the house. If they're, a brother or a sister, or whoever else it may be, that's a recipe for disaster. But here, once again, I'm giving you the broad brush answer, but I think you need to discuss the specifics with your advisor.
Yeah. And maybe create that trust and put it in the name of the trust. And that way you can have the way you want it.
And that's exactly right. Yes.
Ultimately. Okay. That's all the time we have today. Thank you. We appreciate you spending your afternoon with us and taking your time to learn about this important topic. And until we meet again next month, wishing you continued success on your path to financial well-being. See you all next month.